I welcome you now to our first panel discussion, Digitalization and Cybersecurity, New Challenges to International Arbitration. My name is Niuscha Bassiri. I'm a partner at Hanotiau in Berg in Brussels, and it's my honor to sit together, to moderate together with Ricardo, this very esteemed panel of experts in digitalization and cybersecurity. To give you an introduction, I start with Merja Karhapää. I hope that was rather Finnish, the pronunciation. And she is one of the jewels of, in general, of panel discussions when it comes to arbitration, because she's an in-house counsel. She's the chief legal officer at Sanoma Corporation, managing public affairs, IPR, and data privacy. Business responsibilities of Merja are the Sanoma Russian BU, and she has a Master's of Law degree from the University of Helsinki and went also to a University of Bristol. Her special skills, as I pointed out before, will be today explored further, and Merja will give us a perspective from the side of in-house counsel, especially on cybersecurity. Our next lady on the panel is Hannah Rose. She's an associate at Latham & Watkins in London, and she has a very diverse arbitration experience as well. I would say two of the matters she was involved were, one is leading an investigation into irregular conduct of employees of a multinational pharmaceutical services company, including providing data privacy advice. Another one that caught my eye, of a very long list of experience, I have to say, and cases and matters involved, is advising on online company in relation to the merits of a potential judicial review claim against the United Kingdom to challenge data interception legislation. Hannah is equally diverse in her personality as well. You have a Finnish, a Swiss connection, a Swedish connection as well, and the list goes on. She is also the mother of a 3.5-year-old Tyrannosaurus Rex, so he claims, and Hannah confirms. We have then also Eric Schäfer, who is a partner at Kohaus and Florak in Düsseldorf, Germany. Eric is in particular focusing on the firm that Eric is associated with is particularly focusing on all aspects of protecting and commercially exploiting technology and intellectual property. And Eric's main practice is arbitration, in particular with a technical flavor. But I think flavor, that's how he put it, is an underestimation, because actually it's more than that. And Eric is a real expert on IT as well. He co-chairs the task force on IT and arbitration, and co-chaired the task force on expertise proceedings on the ICC Commission on Arbitration. Amongst other things, he was also a member of the e-disclosure task force at the ICC as well. I also should introduce you to Ricardo Gomez, who is our rapporteur, associate at Dittmar and Indrenius here in Helsinki. Ricardo has an LLB from the University of Lisbon and an LLM from the University of Helsinki. He's part of the teams at the Dittmar and Indrenius for dispute resolution, competition and public procurement, data protection, marketing and consumer practice groups, and is also an expert in arbitration. Before I start, I wanted to put up a website, and Jarno helps me with that. We heard already now from Professor Lynn Mell that we should think positively, and the website's name, and in fact, is arbitration. And what is it? And I cannot read it. Oh, no, here, sorry. Information is beautiful.net. So is it so beautiful? Because this website has also an amazing overview of the world's biggest data breaches. You see one of them is Mossack Fonseca, this one, where 11.5 million records were exposed. I point that out in particular because it's a law firm. And of course, as a lot of us are here in this room of lawyers, I wanted to point this out in particular. But this is not only the most tragical point. The other points are also that there are offices of countries, of authorities, that have been hacked as well. You see the US Office of Personnel Management, you might remember that hack, and the Korean Credit Bureau. There are a number of banks in this list as well, or these bubbles, which is a bit scary too, in my view. So we have here, for example, recently, sorry about that, I have to just, okay. Investment Bank, that is the United Arab Emirates Bank. And here, for example, we had a leak of 40,000 records, financial records. I mean, this is all rather serious, in my view. I know also of law firms in the arbitration field that have been hacked. I know also of institutions that have been hacked. We will discuss this in our panel discussion in a short while, but only this as a little warm-up. And now I join the group, thank you very much, to discuss the different perspectives. If I start now first with the perspective from the arbitrator in terms of digitalization and cybersecurity. There are different aspects and different angles one can look at it. As an arbitrator myself, I have been involved in cases where security was written with a big S and the parties insisted on encryption. That was, in my view, a very positive step. It was extremely, and still is, extremely burdensome in my view, and maybe because there are just not enough service providers out there. But it is cumbersome to get encryption of communication be secured. We have also the aspect of the technology or digitalization being considered as a fourth party in an arbitration, where everything is, not everything, but yeah, everything may have an E-equivalent. I think it was Philippe Pinsol who pointed that out already. So I would add first and foremost to that list that he put up email, and then you have, of course, also e-bundles, e-submissions, and e-discovery. There is a foray of e-equivalents for either be it now management tools or advocacy tools being used in arbitration. And then there is, of course, also the question of the equality of arms. So you have to make sure as an arbitrator that there is a balance between the parties. And we have here the point that you have a party, for example, that is very well equipped electronically and wants to use all kinds of electronic devices for presenting its case. And you have a party that is not so well equipped by it because it's a financial burden, or that there are missing expertise. There's missing expertise on the technical side. So a balance from the arbitrator's perspective has to be stricken there. And in this respect, I thought it was very interesting to look at a US court decision of 1997, so it's a while ago, where the Court of Appeals ruled that a brief submitted on a CD-ROM, while the other party was not equipped to read CD-ROMs, you see it's a long time ago, constituted a breach of due process. Now we don't have CD-ROMs anymore. I think most of the laptops don't even have a drive anymore for the CD, but we use USB keys. And that in itself also causes other problem in terms of security, because as soon as you put the USB key into your computer to download all the documents that have been saved on that, there is also a risk of security, of viruses being transmitted. Our practice in our firm is that any kind of USB key there is that we receive, we first scan it for malware, and we do that actually manually. It's burdensome, I have to say, but the other outcome would be just too detrimental. The damage that would have been caused would be just detrimental. I have also heard of a ransomware virus that was hit a law firm recently, where people in the office could see that files on their main drives, on the server drive, were encrypted as they were going on. So that was also a huge scare, because documents that were not saved on the backup disk the day before of the server, but were worked on by the arbitrators or by the lawyers on that day, were actually gone. And it took a while to get those all disencrypted, or I don't know how you call it in English, but anyway, to get them back again. So on these notes, I would like to only throw some thoughts out from the arbitrator's perspective. We will have the possibility for the audience to participate further. We will have a Q&A session now anyway, and with no further ado, I would like to give the floor to Merja, and to let her give an insight on the perspective of the in-house counsel.
Thank you. Thank you very much for having me here today. What I would like to share with you is company's perspective, what we have done to protect us from cyber attacks, and also share my insight as a client in arbitrations. Sanoma, the company I work for, is a media company, and thus first ones to undergo digital transformation. And therefore, everything we do nowadays is also done in a digital domain, even though we still do print products. But the production itself is obviously digital. Examples of incidents that we face, like any other company faces, but possibly we pay more attention to that. Examples of those incidents nowadays that we need to tackle include targeted attacks like hacking, malware attacks. Malware is a fancier name for virus attacks. Unauthorized access, so that someone from outside of Sanoma gets an access to our information or infrastructure. And what we are particularly worried about is loss of devices, because of the mobile devices so much used, and most of our staff are journalists and moving around quite a lot. And we use a lot of freelance workforce nowadays as well, and obviously all they rely on mobile devices. So we pay a lot of attention to cybersecurity, and the need to manage cybersecurity comes from at least 3 reasons. most of all, we want to avoid badwill in our customer relationships. Media company is a consumer company, and we are very dependent on trust from our consumers, but also from our advertising clients. So we want to avoid losing reputation in the eyes of our consumers and suppliers, and also obviously advertisers. And we also want to avoid damages. So it's threefold: badwill, reputation, damages that we want to avoid, and thus invest in cybersecurity. When I think about arbitration, I'm sure that the same drivers apply. There are at least 3 parties in arbitrations. There is obviously client, attorneys assisting the client, and then arbitrators. And to maintain a trusted relationship is relevant in all these relations between attorney and arbitrator, and attorney and client in particular. And the same drivers apply. I would imagine that all of them want to avoid badwill, loss of reputation, and damages. The reason why companies choose arbitration is normally the fact that the financial interest is really big. It's millions of euros, but can be tens of millions of euros, in some cases even more. And therefore, there is a great financial interest at play. In addition, normally those cases are very confidential. Companies choose arbitration because they don't want to have their disputes in public. And therefore, it's not only financial interest, it's also reputational interest that is at stake. Companies never start arbitrations without having hefty reasons. So companies expect at least the same level of IT security from attorneys and arbitrators than what they apply themselves. And then if I quickly just explain how companies safeguard their information, what we have in place is clear governance rules with clear roles and responsibilities about what data we have, who processes the data, and where the data is kept. When there are third parties involved, we take care that we annex data management rules to our third-party contracts. We train employees. There is continuous monitoring going on. We react to data breaches immediately. We also have, because it's the human link that's the weakest link, so we have issued rules, so-called 10 commandments, that are up there. Clear, simple rules that each one of our employees should always pay careful attention to. And these rules include very basic, simple stuff, but surprisingly often people do forget about these. Like, think before you click, or do not open messages or files you do not expect or trust. Like when I get an email from our CEO to arrange a large money transfer from our company to a third company, I shouldn't start doing it. And these are exactly the kind of emails that have been floating around during the past weeks. Third one, protect sensitive information. Then rules about strong passwords. Advice about being really careful when using public Wi-Fi networks. Never leaving mobile devices unattended. And that's one of the most difficult rules, because then you really have to take your mobile device from your car and not leave it in there when you park your car. Remember what you put on the internet, etc. So very practical, very sound rules that show that it really is not so much about compliance, but about secure way of working.
Right. And Eric, having now heard the 10 commandments from an in-house counsel, would those also apply to working as counsel, representing a party in an arbitration?
Well, first of all, I want to thank the organizers for having me here, because I'm a white-haired Caucasian Protestant, 50. So I'm lucky somehow the filter hasn't worked. But to move on to the topic, we are a technology law firm, and for us, arbitration is one of our many activities. And since technology is probably more prone to this kind of attack than an arbitration case, in our firm at least, our security efforts are driven by the need of our clients. So what our clients need is what we try to give them. Of course, as law firm, we are bound by the local laws concerning security, data protection. We have now the EU Basic Data Protection Directive, which we have to apply. In Germany, we have a stricter role. So we have to look for two needs. We have to look for the need of our clients to be in compliance with the law. So if they give us information, they want to be sure that we comply with the laws in regard to this information, especially if it's personal data. We have to look after their innovations, because they give us information about their innovations before it's known to the public, even sometimes before it's a product. Right. So it's very sensitive. And what do we do to safeguard all this? First of all, our employees cannot take with them any information that is in the firm. This is only reserved to the attorneys. So there are very few people who work at home, and these are the attorneys, and I'm just going to tell you what these attorneys can do. They can also not do everything. Our system is behind a firewall. We have email filters, we have a virus scan, and we have to the outside email servers that have a server that handles encryption. So if our clients want to have encryption, we have a server that sits, and if they have sent their signatures, the system directly automatically detects the sender and the signature and decrypts. So within our firm, which is like a fortress, these messages are decrypted, but outside everything is exchanged by encryption, depending on the sender. This is automated. There is a compliance problem, not in our firm, but at the end of the clients, because the client has one employee who is authorized to use the encryption certificate, but not the others. And the clients very often within the company want to send around these messages, which is not possible if it's encrypted. So after a time, first they ask us to do it, and then they abandon themselves the system because it's inconvenient for them. We have our servers in our building. We have a redundant system. So if a part of the building is disabled by a fire or something, we can continue to work. We have data storage outside at about 20 kilometers distance. So if a bomb is dropped on our office, we can start in some 48 hours from another place. Perhaps not with everything we had, but I think we can meet deadlines, which is for a lawyer very important. We can recover everything. For our lawyers who work outside, we have a VPN, a virtual private network. We can log on our system, so when we work from the outside, we work on our servers in the building. And to log on, we have a double identification system. So you have your user ID, you have a complicated password that passes a basic test. Plus, we have a token that we receive for each access. But I'm not going to be too specific about this, because the more you tell, the more risk you create. Because the intruder, with this information, it's recorded, somebody sees it, and then they know how to get more, they know more to get into our system. What we need to know also is that in the end, like a lock on a door, you have also clients who produce locks, and these are also electronic. They will tell you there is not 100% security. It's always a question of the budget you need to breach the security. So if you have a small secret which is not worth much, and the other side has to expend more than it's worth, they won't do it. Only for the important things where the budget is justified, they will pour in the money to breach the security. Now we can ask ourselves, and I come back to this for arbitration cases, what does that mean? A huge problem are the social attacks. You talked about it, the email from the boss. They do some research, they phone, they go to sites like LinkedIn. Yesterday I received a message that my LinkedIn account had been breached, and I already changed my password. But the social attacks are a bit big problem, and also private contacts, because these people gather information and they send messages that cause people within the organization to do things they would otherwise not do. It can also be that they copy something on a USB stick and send it to an address, and the whole thing was a fake. It's not only about money transfer that was not authorized. Yeah? So this is a broad spectrum, and of course emails which are not so clearly from a person with a clear context. It's only the email address and it says please open the attachment. It's something we send automatically to our IT people to screen it before opening. So a good rule is, before you open something that looks somehow suspicious, don't trust your scanner, because the scanners do not always detect everything.
Right.
Yeah? Send it to the IT people, if you have them, to check that in a secure environment where this whole thing cannot spread. Okay, now concerning the council perspective in arbitration. We know we have our infrastructure, we have the established procedures with our clients, which are normally long-term clients, so we can establish stable procedures. We know with whom we talk and who needs the information we receive and send back. But by an arbitration, we have an unstable system. We have no information infrastructure, we just have the net. And everybody uses it. How do we use infrastructure today in arbitration? It's mainly email with attachments. It's just, we have replaced the facsimile by email with attachments, which has many inconveniences, but it's also not very secure. Of course, we can try to convince everybody to send this encrypted, but it's probably not going to work because it's cumbersome, and somewhere in the whole line there will be somebody who's not going to use it all the time because it's just consuming, and they have to change their internal processes because they do not have the same processes we have. So what we see is there is a lack of standard procedures, there's a lack of knowledge and training on the part of arbitration users on these little nitty-gritty technical details which would make everything more secure. Now, do we insist on the implementation on security measures? Yes, if an assessment of the case, which we need to do with our client, leads to the answer that there is information in the file that for some reason has a high value and needs to be protected. In most cases, and I think therefore people do not so much care about security, probably the users, which means the parties, the clients and the lawyers, think that, okay, it's not public, but we do not need this high level of protection. And therefore they do not make the efforts. But in our field, where we talk about innovations and perhaps some arbitration between two competitors who are just leading in the market, there might be information where you need to have this additional package of security. And then you have to insist. When do you insist? You insist when you have the case management conference. And you have to take this up with the arbitrators. The arbitrators, as you all know who do arbitration, normally discharge these things on the parties. They are not very aware of these issues, and they hear and they say, oh, okay, what do you think? Can you agree? And then they try to put this into a sort of consent order. This is not always very helpful, and sometimes it's difficult to implement if one party obstructs and is not so interested in participating in the arbitration, has more interest to make the procedure long and complicated and perhaps find a way to infect it with a procedural error. And if you have this kind of situation, you will not find an answer to these security concerns, and then you will have to look for another type of protection of your valuable information. Then you have to look at what you submit in general, and which is the bit of, because it's not going to be the whole proceedings, just at this bit of proceeding that needs confidential protection, you need to seek an order from the tribunal. And if you know that this may happen, it may have an impact on the choice of the arbitrators you choose. You will probably, if you have this kind of case, look for an arbitrator who has already some experience with handling protection of confidential know-how within an arbitration. You will perhaps look for an arbitrator who is open to technology. He might himself or herself have the facilities to create the infrastructure ad hoc. But if you ask me whether this would be in the beginning, when you select the arbitrators, a really important criterion, which would be if this is not present, we do not select this person. I would, in most cases, probably say, when selecting an arbitrator, I look for a person whom we trust, who has the procedural skills, legally, the legal procedural skills, and the subject matter knowledge required for the case. And the other things are add-ons, and they are not so important. So you will never have everything in one person, and somewhere you have to make a compromise. And I would make a compromise on this technical side and try somehow to cover this myself. If I have on the other side counsel from a huge law firm who is used to cooperation and arbitration, you will always find the appropriate solution to this because they probably will have the same issues. But if you have somebody who is obstructive, who comes from a different background, who will be perhaps a one-time player in international arbitration, this might be a problem. Yeah.
Thank you,
This
Eric.
is what I can say for the moment.
Thank you, Eric. And the point of the lack of standard procedures, I now look at Hannah. Is this something that would also that caught your eye when you did the research on the side of the institutions, or also what Eric said now in the arbitrator appointment? Is this now a new element of suitability for an arbitrator if an institute would actually suggest a candidate if the institute needs to appoint an arbitrator, for example? That's one food for thought. But if you could first please address the institution's perspective.
Of course. I might just stand there.
Of course.
I have a couple of slides.
I didn't know this is permitted. I would have also...
Exceptions.
Thanks. So to complement the discussion, I'm addressing the institutional angle on cybersecurity and digitalization. And just to be clear, I act in counsel role, being at Latham & Watkins. I know that we have several esteemed colleagues from arbitral institutions here, so we welcome your input. And this is very much a framework for discussion rather than the last word on the topic. My personal footprint, I've learned that my surname is very confusing, so here's the roadmap to me quickly. So I'm at Latham & Watkins. I was previously at Freshfields. My background is in philosophy, politics, economics, and law. So the sort of human science angle that Jarno was talking about. I'm a Finn. My husband is Swedish and born in Switzerland. And we have a Finnish, Swedish, English son and a German dog to whom I speak German very badly. I have a picture of T-Rex here to explain that our son genuinely thinks he's a T-Rex rather than a little boy. In addition to being in the arbitration practice of our firm, I co-lead the parent lawyers group at Latham & Watkins, and I look after pro bono services, which means giving legal help for free to those who need it. Looking at the big picture, one wants to be critical about this question rather than rush into thinking if you are an arbitral institution, you must definitely put in place all bells and whistles to do with cybersecurity. Is this futuristic fantasy or is it prudential planning? Is it really relevant? And also, Eric made the excellent comment in our prep email discussions that you do not need the Maserati to drive to the shop around the corner. So are we trying to crack a nut using a sledgehammer? Let's be conscious of what is required. Then there's an interesting question about what arbitral end users, like Sanoma, and arbitrators may be expecting of institutions, and perhaps what should be expected, and particularly looking at it from an institutional level. And I'll come back to that question. Also coming out of the discussion in the field is the question, is there conflict between efficiency and accessibility of arbitration versus the integrity of the data that is being shared? Here's an article by counsel and deputy counsel at the ICC talking about how the accessibility brought on by the internet, the use of Skype and cloud, mean that in emerging economies, arbitration is becoming possible and very popular. The focus is almost singularly on efficiency in this piece. So I think we need to ask Is there a conflict that needs to be addressed? Now, touching on the point about is this futuristic or actually realistic, some stats from a global and the UK perspective, since I'm based in London, there's been a 66% year-on-year increase of security incidents, according to PwC. And more than 80% of UK companies suffered a security breach. And this is according to the government communications headquarters. That's quite a high number. If you look at the cost, which Merja was touching on, for a UK company that suffers a data breach, that's a cost of over 300 million in damages, resulting from regulatory fines, which may not be that relevant to institutions, but there are definitely reputational and commercial risks. And then necessarily there will always be changes to the IT infrastructure as a result of a crisis like that. Now, bringing this to the arbitral context, is this happening? Niuscha pointed to the most prominent example. We did a data search globally for breaches in this context, and national courts are a good parallel here. Obviously, the Permanent Court of Arbitration has suffered a very prominent data breach with, sorry, these pictures are fairly ungranular. But in a case involving a sensitive maritime dispute where there was a persistent threat by Chinese actors onto the website by exploiting a weakness in Adobe Flash, which meant that that website became unavailable, and it further permitted access to the systems of those who had used computers which had the Adobe Flash, for example, a law firm computer, which is a reminder of the interconnectedness of this issue. Several national courts have had this problem in the US, in Pakistan, in India, in Israel. And often there is a political angle to those hacks. In an exit case between Libananco, a Cyprus company, and Turkey, there was surveillance by Turkey into the email communications of Libananco and its counsel, and Turkey did not deny this, but they called it legitimate security surveillance. Also prominent is the case of Kazakhstan and its emails with its counsel, which had been posted online. And we return to that example. My apologies about the picture. Now, how do you go about assessing whether this is a relevant risk for institutions? It's a bespoke exercise. So there are no off-the-shelf policies that you can take. And as Jarno was saying, you look at the environment, and it is a complex exercise. And so actually this applies whether you are an institution or a law firm or a company or any other actor that might be holding valuable data, including individuals. So first of all, be bespoke. So then trying to put some framework onto the exercise, there should be a system. And the first question is, what are the key assets? What are your crown jewels that you're trying to protect? And now, broadly, if you are an arbitral institution, you will have confidential submissions. As Helena mentioned, confidentiality is one of the big drivers of why we use arbitration. There's also evidence, witness evidence. There are also personal details of arbitrators, perhaps dates of birth, bank account details, etc. Now, then you ask, who might be after this information? And this is key, because together, those two questions will tell you how the attack will be likely to take place. So then you can categorize into like profiles of kinds of attacks that you can then assess and see if they're relevant. You can then put in place that a policy that helps. So Libananco is an example of data theft. Hacktivism. This is interesting, and these are the most prominent headlines. So the Permanent Court of Arbitration, the Supreme Court of Pakistan, and Sony. And so Sony had a very, very public hack. And there's a lot of public discussion about the emails that were leaked as a result, which were embarrassing. But the much more troubling issue for Sony internally was the fact that its data system, its computer system, was unavailable for a very long time. So this is a big risk. Here's an example of a hacktivist message from a court in Pakistan. Somebody hacks the website, puts a message saying, "Where is the security? Security is just an illusion. Greets to all Pakistani hackers, Pakistan Zindabad." And so that is a reputational risk. And inevitably, with that kind of message and overtaking of the website, the system becomes unavailable. Now, we ask, so who's the likely target? And this is important because of we talk about the ecosystem of cybersecurity. And you have to look for the connections between actors and look for the underbelly. Who's the weak link? And so financial institutions contain, as an example, contain a lot of information that several players want. But they tend to have very, very safe systems to protect from attack. So law firms then become the next alternative. So law firms then tend to have very strict safety systems in order to protect the client's data, not so much their own data. Because the sophisticated players will go through the chain of who's looking at whose data and who has it. So it may not be the actual entity whose IP data or trading data it actually originally is, but they're legal advisors. And so in the PCA case, if you are, that shows the interconnectedness. So if you are a law firm, you use a laptop that has Adobe Flash, you go into the Permanent Court of Arbitration page, then your systems may be compromised. So there may be a domino effect. So then look at the consequences. And Merja touched on these. So loss of confidentiality of the material, that would seem to be a very serious thing. Loss of integrity if somebody were to hamper or tamper the data that you have. Availability of your own systems, which was very difficult for Sony. And loss of confidence in the system generally. And then, after all this, you can then look at whether the existing measures you have in place are sufficient, and if not, how you modify them. So this is very much an internal exercise for the institution, and it results in the kind of bespoke rules that Merja was talking about, the 10 commandments. Now this is the last thought, concluding thought. So we can, in this discussion, we can talk about what is the state of play, and then what perhaps should be the state of play. If we envisage that this large-scale hack could happen to an arbitral institution, would it erode confidence in arbitration as an institution and as an exercise? So that would be an important question to ask. There may also be a discussion about whether indemnities might become relevant in the field as to who's going to be guaranteeing to whom that they won't suffer financial consequences if this happens. So I'm part of the arbitration team, and my special thanks to our cybersecurity team who deal with these attacks on a daily basis.
Thank you, Hannah. In fact, I looked up how expensive it is to hack, and it's shockingly cheap. So there is this underground black market, and it's just really amazing. Emails are actually now again on the rise for whatever reason, but on the rise means that you can buy emails, 1,000 stolen email accounts, something between 50 cents and $10. 1,000. And so these are the emails that then I get, my email address, sending to myself or to someone in the firm saying, please, can you please review? And there is an attachment. And that's exactly one of those very, very simple but still most efficient hacks how to get into a system. And indeed, the human error side is still, I think, the biggest risk, as we heard also, and some other experts said that too. And on the PCA hack, I have a small little anecdote myself, because I was actually talking to an associate about a specific case, and I asked her, can you actually check on the PCA's website? It's all written there because it's a public case. And she's a younger generation, so immediately she was on it. And she said, oh, it doesn't work, it's down at the moment. I was like, oh, probably hacked. And I go away. The next thing I hear the next day is that the PCA's website was hacked. So I didn't know of anything, okay? It was just a joke, nothing more. But it's just scary. Merja, what is the weakest link in your view? We said human error is probably the biggest threat, but in the setting of an arbitration, would you think that the weakest link is maybe an arbitrator, as Eric pointed out, would maybe lack the sensitivity of new technologies, may have a Gmail account. The other day I heard AOL account, that's really back from the days. Or is it, you think, actually on the side of the arbitration rules, that they do not foresee of a specific secured means of communication?
If we think about the amount of information that is delivered between arbitrators, attorneys and clients, I guess that's where one would find the weakest link, particularly if general email accounts were used. I had a quick look at the arbitration rules, and there were very clear rules about confidentiality and information delivery. But to my surprise, those rules, even in respect of information delivery, were focused on aspects like, is there a proof of receipt? And ensuring that parties are treated in an equal and transparent manner. There were rules about how to deliver copies, etc. But there was nothing about means of information delivery. And yet, I've heard, and actually I've seen, that there are arbitrators who actually do deliver highly confidential, strictly sensitive material over Gmail or Suomi24 or any other general email accounts. So, I mean, that is like really leaving your front door open.
Right. So, and from a counsel's perspective, Eric, is that something that you would consider if you would conduct arbitrator interviews prior to nominating them? Is that something that you would check in those interviews? You mentioned already some criteria how you would go forward. And the other point is, how do you deal then during the arbitration, ideally at the very beginning of the arbitration, with these security means and terms of communication?
May I say something to start with? You talked about hacking, but we should be aware that hacking is a very broad term, very unspecific. I mean, if they hack the website and they put a funny face on your website, this is not nice for your external communication, but it's not really a threat. So if we talk here about compromising a system, it's about information interception, and it's about system penetration. Personally, I believe that system penetration is the most serious threat, because then these guys are in your system and they look around wherever they like. And this is done exactly by sending a small piece of software to some of your systems, and then they pull from other sources slowly the software they need to open the doors in your system and to compromise it. And I forgot to mention this, what we also have, we have a penetration surveillance. So you can even if you have these outside protections, it might be that there is a not yet detected type of malicious software that does this, and you can only detect it if you look for unusual activities in your system. So if suddenly huge amounts of data are being copied within your system that would normally not be copied, you know that something is going on. And these are the only ways to find this out. And if we have these reported cases, it doesn't mean that there are not many more cases. I believe there is a very high amount of undetected cases where information is lost without the owners really finding out that they lost it, which is even worse because they cannot take any action. But for the arbitration, I believe we tend to put people on a short list whom we know, and we know about their technical capabilities. So the interview is normally very short. It's only about conflicts and availability. But might be that one day we have a case where we have to conduct an interview, but normally we appoint people we have somehow seen acting, or people whom we trust have seen acting. This is how we get the information. And we would then identify the relevance of the information and whether it really needs to be protected. And if it's really some parts of the information that need to be protected in the arbitration, we would put that on the table as early as possible and insist that some solution is being found, either together with the other parties and the arbitrators or by an order.
Right. And Merja, from a company's perspective, if these systems need to be put in place, they cost money. What are the considerations on the side of the company, you think? Always go for security and happy to pay more for a secure system. And we're not talking about small amounts here. I know I myself am involved in a council case where the system is extremely expensive. They pay a license fee of a couple of €1,000 per month. Now, if an arbitration goes on for, let's say, 2 years, 2.5, 3 years, I mean, it's a substantial amount that comes together.
Obviously, the amount of money that companies need to spend in cybersecurity are significant, but nevertheless, it's always a balance between the cost of the investment and then the value added one gets with the money. And I mean, possibly we could prevent all incidents from happening, but then most probably our company would not function anymore. So there are two sides. First of all, preventing the obvious threats, and then ensuring that we can recover our systems as quickly as possible by patching software, etc. But when I think about this weakest link, this email transfer, that you can buy a secure service from teleoperators, and that costs a ridiculously low amount of money. So when thinking about the interests in these arbitrations, as opposed to that 10 or 100 euros per month, it's like really, I guess, due to ignorance of people rather than a question of cost.
Right. And Hanna, from an institute's perspective, now, do you think, we have heard already from Merja as well, and we know from Eric that the institutional rules on arbitration, they don't provide for specific security means of communication. Do you think there is indeed room for further reforms of rules of major arbitration institutions to align the security measures in terms of communication?
So I think it's always a bespoke assessment, what's required for this case. Maybe it's best not to be too specific. Maybe it's just something that should be encouraged to be raised at the early stage when the terms of reference are being drafted. And there's a procedural conference where there's a discussion of the needs for that specific arbitration. Maybe that it should just be encouraged to be a specific bullet on the agenda, and then maybe that will trigger the discussion that needs to happen.
Right. And yes, Eric?
I think that we probably can all agree that cryptonomy is going to be an answer to many issues. You can encrypt documents, you can, by digitally signing, secure the integrity of the document so that you can see whether it has been tampered with. And I believe that the institutions should team up. Somebody has to start, some institution with a good name, and get the others in the boat, that every arbitration practitioner can get a digital identity. This is a signature card. This is my digital identity as a German attorney, of course. It has a certificate. It clearly shows who I am. It is registered, so it can be verified on a public server. And with this, I can encrypt, and everybody can get my public key and send me information with that I can decrypt. Not the firm, but the individual lawyer. And this would be the start. And then you would have a basic infrastructure you could slowly build up that would be the same for all the institutions. So they would have some basic technical solutions that they would all use, ideally something that is open source, and into which their individual systems can plug in, and to which the arbitrators can plug in to verify whether what they have received is really coming from the person that purports to be the sender, and whether that document has been changed somehow in the meantime. And if we would have this globally, and there would be many people that would force everybody who goes into arbitration to get also digital identity, it should not be very expensive. And then we would already have solved a big part of the problems we might face. And the rest can follow slowly, I believe.
That's a very interesting and good suggestion. And I'm now deviating a little bit, Ricardo, you might excuse me. But because we have, of course, representatives from the institutions here, and both Heidi and Andrea Karhapää, Heidi from the FAI and Andrea from the ICC. That's now a point where I would like to hear your views, and I'm sure also the others in the audience. And for that, I have this catch box, which is a microphone. It doesn't hurt if I throw it. And since I'm the moderator, I took the liberty to throw the first time. So if I first can start with Heidi to get your view, and then you can throw it to Andrea.
Good job.
Thank you, Niuscha. Do you have any special questions in mind, or just an overview?
About the suggestion that was made, I think, in unisono, in fact, on this panel, both from Merja, from Eric, from Hannah, about the institutions aligning maybe a standard for secure communication. We know there are a couple of institutions already that have secured websites, or Eric's point now with this token, an identification token. The token that we use for VPN to log on remotely is exactly that. It shows who's logging on, and it identifies. So it's a control. So what do you think about this?
It's a tunnel. It's encrypted. So you work directly on the server in the firm, and the communication is encrypted.
Yeah, I think these are definitely questions we need to consider at the institutions, and we of course have done so. Still, I think here at the Finland Arbitration Institute, and many institutes as well, also the bigger ones, so we are still quite traditional in this sense that many documents are sent by posts, some by email, of course, and I have seen it, as you said, that there are arbitrators using Gmail accounts as well. So I think there definitely is questions we need to consider, how to best secure the information, and that there are no leakages happening.
Thank you. And Andrea, thank you as well. Maybe you can also elaborate on Netcase and its successor, if there is a successor system.
Sure, my favorite topic, as you know. But first of all, I think two things and two aspects. What parties and arbitrators acting under certain rules of arbitration can do or should be required to do. And here I think you have to bear in mind, at least as far as the institution I represent, that we work literally from parties and arbitrators from all parts of the world, lawyers, non-lawyers, people who are sometimes really not equipped to observe certain rules. We recently had the case where communication was sent to an entity we shouldn't have received it. An arbitrator was probably responsible. When we or the parties inquired, it turned out that this arbitrator from an African country, very eminent arbitrator, former member of the Supreme Court of that country, he alleged that he had been hacked because he used to do communication on the case from the cyber cafe. So this is the reality we are facing and the difficulties we are facing. As far as the institution is concerned, as you know, there is this long story of a system, a new IT system at the ICC, which would provide access, not only a case management tool, but also something that could be accessed by the users, meaning the parties, the lawyers, and the arbitrators. And this is definitely something that we should consider in that context. Coming to you and Eric's proposal, I think there is certainly room for agreeing on a number of principles, not really for translating them into practical, technical requirements, because the experience of different institutions is quite diverse. But on a number of basic principles, I agree there is room for agreement.
Mm-hmm. Thank you. Ricardo, your questions or your comments?
Yes, if I may start by summarizing what has been said and a few notes, and also to further comment on the alliance. I think that the law firms have taken the step ahead, and I've heard that there is some law firms who aligned to, or formed an alliance to have a cybersecurity common strategy. So this might be also a tip for the arbitral institutions. But starting with what Niuscha said from the perspective of the arbitrator, you said that parties sometimes request the arbitrator and the whole arbitral tribunal and the communications between parties and arbitrators to be secured through encryption and the files to be sent in a certain format. We have the e-briefs, we have e-discovery, we have everything E nowadays, but we didn't touch on the new tools that basically analyze the data that lawyers send to an external, and that company analyzes all the data and tells the lawyer, you should interview this person and this person and this person, because they are the most common persons referred in the communication between certain interviewers. And I'm afraid actually that my job is in danger, because the next E that I see that will come into place is the E-associate, the E-trainee, the E-partner, and then we have the E-arbitrator.
Yeah.
And what will happen to all of us?
Well, I don't think so. There is
not for the partner perspective.
Yes. No, but there is in this the TAR. Also, that's technology. All kinds of acronyms. You go crazy about it. So TAR stands for Technology Assisted Review. That's indeed for document disclosure, a tool that is used sometimes successfully, sometimes less successfully, and finding the red herring and some very juicy documents by feeding into the system either keywords or the system itself selecting some keywords. So, but I don't think you will be replaced, Ricardo.
Thank you. I hope my bosses think the same. I would like us all to bring us now all together from the outside of the toolbox, but inside the playground of international arbitration. And we have all concluded with all your presentations that cybersecurity is indeed a problem, or at least a challenge. But what happens when something happens, when some emails are hacked? So I would like to bring maybe all the members of the panel together and then get the input from the audience as well. So a practical example, if Merja gets a dispute and says, now I have to hire the best lawyer in town, and contacts Mr. Eric and says, I have this dispute. Mr. Eric files the request for arbitration according to the FAI rules, of course, and brings the client of Hannah into play. The parties agree, according to the FAI rules, to appoint the chairwoman, Niuscha, as the sole arbitrator of the dispute. And at some point during the proceedings, Eric decides to hire someone or to do it himself, he will tell us later, to hack into Hannah's email account and to try to find some communication between Hannah's client and Hannah. And Eric steals 3 emails. The first one is the Amazon bill that Anna just ordered 2 books, one titled How to Survive the Long Finnish Dark Winter, and the second one, Finishing Finland. He does not use this in the arbitration proceeding. The second one is an email between Anna and the client with the subject, do not produce, privileged, and the text or the body of the email saying OMG. Then the third email that Eric steals is an MP3 file of Finnish tango that Anna's husband sent to her. He also does not use it in the arbitration proceedings. However, the privileged email that Eric got access to is the key to the arbitral proceedings, and he sends it over to Niuscha. And Niuscha opens the email, okay, one more party submission, and says, okay, now I know that the case should be decided in favor of claimant because this document proves that Hannah and the client did something wrong. So my question to Niuscha is, how would you decide on the admissibility of this evidence that has been illegally obtained? My question to Eric is cybersecurity somehow an incentive on not taking the recourse to document production? So if I can get the document from some other source, why wouldn't I do it? Of course, I will face criminal charges later, but the arbitral proceedings will go on and I will win. The question to Anna is this really a threat posed by the electronic or the digitalization of arbitration? Because as we have heard now from HIAD Merja Karhapää, documents are sent still over post. So maybe Eric could have just waited for the client to send you these documents over post, open the mail, wait at your door and see the documents. And the question to Merja is, when you hire legal counsel, do you actually ask what kind of security measures do you have in place? And if we go to arbitration, should we go then to an arbitral institution that has certain measures in place? And I would like to hear your thoughts and the audience on this.
I would like to give the floor the opportunity to put yourself in the shoes of the arbitrator, because I don't want to take too much time, but and I'm more interested to hear the expert's view here of the audience. So the question to the arbitrator is, are these information and documents retained by Eric through a hack, are they admissible? In particular, the privileged one. Are there any views on this? I'm sure there are. There's no right or wrong answer, basically, because it's a typical lawyer's answer that it depends. But
No. I have a clear answer.
Yes.
One answer is, as attorney, I would not try to obtain information by illegal means. This, at least, this act to hack, again, it's not precise terminology,
yes,
would mean that I breach some criminal laws. Mm-hmm. So I wouldn't do it myself. I would be vulnerable.
Hire someone else to do it.
Because first it would be a crime. Secondly, I would get disbarred because it would be in the exercise of my profession. And it would also be irrespective of whether you look at it from one side or the other, it would not be ethical. It would not be okay, yeah, just on a human level. This is something you should not do as practitioner. And so, okay. But now imagine that my clients retain a private detective. They are desperate. They lack information on this case. They are desperate. And I have already made a request for disclosure, and Niuscha has rejected all this because she's a bit typical German who thinks that document production is a bad thing. So she rejected everything, and my client is in an utter need to prove that the others are crooks. And because they are in this utter need to prove that the others are crooks, he has retained a private detective. And someday the detective comes into my office, has a brown envelope, you know these infamous movies, yeah? And I tear it open and I see a copy of this email. Yeah, of course I'm going to use it because I have not caused this to happen, but now I am in the possession of information that is important for the client. So of course I will introduce this information into the case, and if this is challenged by her counsel, I will say it might be that it was not it was obtained by illicit means. I don't know. I was not present. I didn't participate in this. It just was delivered to me. My client didn't tell me how this happened. But I believe that no party should have the privilege of availing itself of legal protections to cover up a violation of a fundamental duty, which is the duty to tell the truth in the proceedings. They have lied. They have committed an act because they could very easily make a statement about what really happened, and they have just denied, and normally they would have to tell something about what happened, and they have covered this up, which as such is also perhaps a criminal act under the I don't know how it's in Finland, but if this is what happened in Finland, it could be perhaps, what was it, Prozessbetrug, we call it in Germany. What would be the English term?
Fraud, I don't know, some kind of a fraud,
yeah.
procedural fraud.
So I would argue this and say, well, of course it must be admitted. We are not in criminal proceedings, we are in civil proceedings, and this is admissible here. And of course I know that there could be a discussion about this, especially if you have a common law firm that is used to other standards, but here we are in Finland, we have agreed to Finnish law. In Finland there is no so there would be a chance. And then I would say, okay, it depends, on how you decide, because I have to be more persuasive than her lawyers. Yeah, that's life.
You fall back on the normal rules that we know about due process and weighing the balance between the two parties and whether and also the evidence that has been produced as well. I think it's interesting to know that from a arbitrator's perspective, there's of course another point unrelated to this case scenario, that because the arbitrator has access to the biggest territory in the world, that's the internet, the arbitrator, him or herself, can also do some research. And maybe the arbitrator would actually find out information about a party that is not in the record, but that is in the public domain. So that's also an issue, what to do in this point. So as an arbitrator, should you put it then to the parties, or should you refer to it in your decision, whatever kind of award or order it may be, and say, well, it's publicly available, it's in the public domain. So the whole one is the illegally receive documents and information, and one is the very legal way of gathering information by a proactive arbitrator as well.
Can I just say on that, to answer Ricardo's question, I think it seems that it's easier now because of the volume of digital data. It seems easier to intercept than it was in order to, if you went and stopped the post and took it out. So the volume is larger. On the procedural point, if it is the case that document production doesn't produce what's relevant in the arbitration, isn't it a question of looking at whether there needs to be harmonization or tightening of the disclosure rules so that relevant things actually do come up? And this, I think we should ask the question because a tribunal recently considered whether hacked evidence is admissible in arbitral proceedings. And one of the considerations was they need to prevent the cybersecurity breaches. On the other hand, evidence that is out there on record should be considered. So that's a point to think about.
Right. And when looking at it from a client's perspective, in order to have arbitration, in order for arbitration to have the respect and position that arbitration has used to have, it's quite important to start sharpening the rules around information discovery, information delivery, and also confidentiality. Because even confidentiality is something that nowadays is different for different parties in an arbitration. And in the end, it comes down to making agreements with the parties in order to be ensured that there are enforceable obligations in respect of confidentiality. But the other areas, information delivery and disclosure requirements, are something that obviously parties can't influence effectively if not everyone agrees. And therefore, in order for companies to choose arbitration over court proceedings, these things must be in order. Yeah.
Very well said. Are there any comments from the audience or any questions that are to be put to the panelists? We would welcome, of course, your input.
I have a comment.
10 seconds.
No, there's something really important in the last thing you said, which is not really related to cybersecurity. This is about learning about facts on the part of the arbitral tribunal, and these facts have not been adduced by a party. One can ask the question whether the arbitrators may introduce this kind of fact into the proceedings, and there can be a split of information. But if this information is relevant for the case, for me it's excluded that you put it into your final decision. You need to put it to the parties so that they can argue this new fact. If it's really relevant, I mean, an irrelevant fact, it doesn't matter. But it's really relevant and they have overlooked it, you cannot just put it into your final decision. This is, I think, in all legal systems, this would be a reason to overturn the award. I would be very surprised if an award with this kind of incident would stand the test. This is really, for me, a pillar of due process, that the facts must be there and the parties must have had the opportunity to comment on these facts.
Yeah, I would agree with that as well. I would put it to the parties as well. Whether it's a reason to set aside an award, that depends, of course, on the jurisdiction. But I would agree of it for due process, absolutely. And where's the harm in not putting it to the parties? But I would be, of course, also interested to know how tech savvy are you? Now, there is. You have pointed out a speaker. Okay, thank you.
Karitta Wagner-Lindholm from Helsinki. That was not the question I was going to address. Eric and I have discussed it sufficiently, and I think that this is not maybe what I want to discuss. But what I wanted to ask is, Eric, what was your position as a German lawyer to the chairwoman's question as to whether you would go ahead and Google things that you thought that were important to the case, but that the parties had not put before you? Because I think that aspect was not responded to. Thank you.
Right, because there are perhaps different answers depending on the case, where the case is taking place. I think legal cultures have different answers to this issue. If I would go to the US or London, I think it would be a deadly sin. If I would look at Germany and other parts where you have a more proactive perspective on the role of the arbitrator, I would not be so certain. But I think it has a certain taste to it. If you do it or you just happen to know, it's difficult to ignore, and you have to put it to the parties. But to start searching yourself, even if you have the impetus, because the parties, it's visible that it's deficient what they submit. I think there is a border which you should not transgress, but it's clearly within a common law context. If you are a German arbitrator and you are in a case where English law applies and there are all over the place English lawyers, you should not do this. This is clear as crystal.
Thank you very much. Yes? You have to throw the... Oh, okay. You're doing this. Thank you.
I really just wanted to hold the toy for a while. Very good. I've got one question which I think probably flows logically from the discussion. And I'm looking at it from the perspective of the clients. And when they instruct a lawyer like Eric, and in turn when Eric decides on the arbitrator. And I think it flows from what you said about indemnity. I speak as a lawyer in private practice. I'm not an arbitrator. I'm not an insurer. But one question for Eric would be in relation to your terms and conditions, because it seems to me that when a client instructs a lawyer, he expects that lawyer to be competent, and the lecture I've just heard makes me think that competence includes cybersecurity competence. And if you were being instructed, maybe some of your clients would say, I want to know what your systems are, and in turn, in order for you to have the so-called seamless web, you would need to notify your insurers so that they would cover you just in case there was some human error during the course of the process. In practical terms, that means that when your client instructs you, are you looking at your terms and conditions as between you and your client, and are you then, as it were, limiting or excluding liability, but equally passing it on to insurers? And the knock-on point, which it seems to me is not unimportant for a group like this, is that if you are advising a client to go for an arbitration system in one jurisdiction or another, or an arbitrator, does that system have its own cybersecurity or not? So why would you agree to appoint a competent African chairman if he's incompetent as regarded cybersecurity? And this was fun. Thank you.
Well, if I would be my own lawyer, I would of course say, yeah, we need these terms and we have to be very careful. But since I have no lawyer who counsels me on these matters, I must admit that I retain my clients on a handshake basis. So I have nothing to look at but the law in that regard. And to tell the truth, I'm not so concerned about my insurance because that's life. I mean, it's a free profession, and the risk to be exposed to claims by dissatisfied clients is part of that. And I have a higher insurance than is required by the law. So this is the answer for me personally. But of course, there are unmentioned expectations on the side of a client which easily create problems. This is because this is not the core of the activities of a lawyer. But of course, today a client would expect that. But if for the client this is important in the client-attorney relationship, the client would need to address this in our first discussion when we decide whether we would work on this Monday together. And I think this is the first basic rule. You know, it's not so important what is in the small print. What is important is that you deal with the client in all respects that are important for the client in regard to the specific mandate. This is normally remuneration, but if IT security is a matter and our clients have this, and our clients normally send us their terms and conditions, which we then accept, with perhaps some small changes, then we deal with this and we look at it. And we have these kind of agreements with our clients, which are very elaborate. We have Chinese walls in the firms. We are plugged into the IT systems of our clients and do not work in certain aspects on our own computers. It's all on theirs. And many solutions, but you have to be explicit about that. It's not a question of terms and conditions, not a question of insurance. It's just meeting the client's expectations. This is the key to a good relationship with the client. Was that a sufficient answer to your question? I'm not certain.
I'm afraid we have to leave it here, though, and you can continue happily during the coffee break. We did go a bit over time, but it was authorized. So it leaves me to thank Merja very much, Hannah and Eric as well for the time, for the input, for the expertise, Ricardo for all the work behind the scenes and also here on the scene, of course. And I relieve you now into the coffee break. Thank you very much.
Thank you.